Chair lays out House Bill 969 by Cook and representatives, and recognizes Representative Cook to lay out the bill.
Thank you, Mr. Chairman. Thank you for the opportunity, members, to lay out House Bill 969. I'll preface this bill with saying this is probably the shortest bill I have filed in my short tenure here in the legislature, but it is a very meaningful piece of legislation. It's literally one paragraph. I'll warn you, one of the other bills I have will be one of the longest bills that I filed. But this bill simply talks about another option when a non-custodial parent is denied their right to possession. And so currently under Texas law, there's a provision in the Penal Code 25.03 that is actually a felony offense where a law enforcement officer can charge an individual with the crime of denying their children. I've been practicing family law since 1997, actually even before that as a law clerk. So in my experience from 93 through 2023, which is what a 30-year period, I've never seen a violation under 25.03 in the Penal Code ever occur. That doesn't mean it hasn't occurred in Texas. I've just never seen one. And I only say that to say this. This is a very good tool to have in the toolbox. This is a situation where if a non-custodial parent, a lot of what you've heard in the committee is if that's the father, if he shows up to get his visitation and he's denied, he will have the opportunity to call, and a police officer would actually be able to come out and issue a citation. It's a Class C misdemeanor, which is a fine-only offense up to $500. And I think in my experience, this would be a more meaningful tool. It would be more widely utilized. This is not mandatory. It's permissive. A city or county would be able to pass an ordinance that would propose a civil penalty for interference with child custody. I'd be glad to answer any questions the committee has. Otherwise, I would like the opportunity to close when appropriate.
Any questions of Representative Cook, members? I guess I was wondering, Representative Cook, would the police officer who shows up have to resolve factual issues or something, or would he just look at somebody has an order that says?
I think that's what you're going to see. I think a lot of times, Chairman, you probably have had the same experience at this state of the game. If a officer is called out, I think we all know that the officer is most likely going to say, call your lawyers, go back to court, and that sort of thing.
Right.
So this bill was actually offered by Representative Raymond last session, and I was sitting on this committee, and at first blush, I didn't really think it was a great idea. But then after I saw the practicality, I really do think it's very effective, because I think it's a situation where if the custodial parent is denying visitation and a citation is issued, my guess is that that's going to stop there. So I think it'll be an effective tool, but it would require what you're talking about. I think it's going to be a situation where an officer is going to have an opportunity to read a court order and see what it says and make a determination. But that's what they do on almost any type of crime.
Right.
Talk to both sides, he said, she said, and make a determination.
Yeah, because I wondered if one parent says, we're supposed to drop the kid off at XYZ place. You weren't there, so I brought the child back home. Mm-hmm. Police shows up and says, well, it looks like you're engaging in something that's different than the court order says. He said, well, yeah, no, I had no choice. And what's the police officer going to do at that point?
Like I said, I think it's just a situation that the officers find themselves quite often where they're just, they're going to have to do a little bit of investigation, ask some questions, and make a determination.
Okay.
Yes, sir.
All right. Let's. Do we have any people? Okay. Well, if no further questions, we'll start the public testimony.
Thank you, Chairman.
The chair calls Taran Champagne.
Good evening. My name is Taran Champagne. I'm representing myself, and I'm for the bill, and I think I got it right first up to bat. So to Representative Cook's point, right, Texas Penal Code 2503 is somewhat of a joke of a law in Texas. Not that it's a joke and that the way it's written, but in the fact that it's not enforced. Custody orders in Texas are oftentimes minimally enforced. He even testified that, he's never seen it enforced. Parents, mainly fathers, can go for years without seeing their child because one parent has withheld the child from them. Parents are routinely told by the police that interference with child custody is a civil matter, despite being in the penal code. And additionally, odious to what often happens with this, once the parent is finally able to get custody of their kid, they got to go through reunification therapy with their kid because they haven't seen him through years due to the malicious intent of a parent. One has to look no further. There's a Facebook group, the official Team Texas Penal Code 25.03, Interference with Child Custody, to see how much of a problem this is. I checked last night and it had 2,367 members constantly asking questions on how they can get their child custody enforced. I get it. No one wants to send a parent to jail because they fear it might be traumatic to the child. However, what is equally as traumatic is playing head games with that kid and keeping them from a fit, willing parent for whatever sick or twisted agenda or maybe upset feelings that one parent has. I've only had to deal with this once, and it was here in Austin, and fortunately, APD came out, and I know they get beat up in the public a lot, but a good kudos to them. They talked to my son's mom and told him, hey, you can't do this. You can't withhold him. There was a miscommunication. Just turn the kid over, and we're good to go. And I ended up okay. But I'm one of the rare people in a situation like this. It upset my kid a whole bunch. By authorizing a civil penalty for failure to follow custody orders, local governments have another tool available to them that's not just jailing one parent. If individuals know there's a consequence for failing to follow those custody orders, they may be more inclined to follow those orders as written. As it stands right now, while there is a penalty on the books, it's not enforced. And those kids, they're denied that access to a loving parent. This is harmful to children, and we need to do something about this issue, and I believe Representative Cook's bill would help solve this problem. Please pass this bill so it can become law and help our children. Are there any questions?
All right, thank you, Mr. Champagne, for your testimony. Any questions, member? Not hearing any, thank you.
Thank you.
Chair calls Brandon Johnson.
Brandon Johnson. I'm going to testify, change my testimony to neutral, and I'm representing myself.
And you're shown now as being against the bill. Is
That's
that
right.
But you want to change that to for?
Neutral.
Neutral. Okay. With your permission, we'll do that.
Yes, sir. Thank you.
Okay.
I appreciate the sentiment in at least proposing the bill. That's my reason for changing it to neutral. But the bill admittedly does not have any teeth, and because the language is may adopt, so it has no shall or duty to enforce. And I sympathize with that because my concern is this would be used as a punitive harassment to a non-custodial mandated absent father who's trying to maximize the little bit of time he does have with his child. And I've had this happen to me, so I'm speaking from experience on this particular bill. Now, if it were amended to say there was mandatory for habitual behavior, where 5 minutes before, whatever, it could become habitual, and it does in many instances. Then possibly amend it where it does have those teeth that says, look, she's going to have to pay $500, go to jail. As soon as you start implementing some consequences for that behavior, it'll stop. And then as far as the police go, if they'll just create a file, which they in most jurisdictions they are not doing, if they would just create a file, then they would be able to establish the history and able, to be able to connect the dots, because it may not be the same officer every time. He doesn't know the history of the case. And then you have documented evidence so that so that the interference of child custody could be enforced. Thank you.
All right, Mr. Johnson. Thank you. Chair calls Cody Taylor.
I'm Cody Taylor, representing myself, and I am for the bill. And thank you, Representative Cook, for understanding constraint of parents. So for years, since this has been put in, I've witnessed myself through others. The possibility that they may never see their kid again. So I'll put it to you this way. It does say may. It would be awesome if it said shall. The reason why, aggravated robbery. There was a case not too long ago of an individual who came in to a convenience store. We hear about it on the news every single day almost. If you put that terminology in there and said a city may devise a ordinance on aggravated robbery, well, they could, or they don't have to. But if that aggravated robbery turned into murder, it would be totally different, right? So we're now hearing of these situations where they're going to a drop-off point and they don't care where it's at, and it's becoming violent. It's becoming also deadly. When I say this with all due respect, why do we even have to have this? Our penal code is set in place. Our police department and officers are trained to uphold the penal code, not to come here and say it's civil. If it's already in the family code and it's already a part of the penal code, then why would we need this? And I'm only asking that in more of a retro conversation. I have been a part of this. I have tried to file it. I have actually heard district attorneys tell you that we're not going to push it. I've actually heard officers say it's not going to be enforced. Our DA won't do it. But yet they'll break in a door to go get a father that has a warrant if they have done anything against the child, whether it be a false allegation or not, whether it be child support or not. They will break down a door to go get that father, and they'll put him in jail. Again, it goes back to, why do we need this when we already have a penal code that establishes it? I think that it should go back to the root is why are judges not enforcing it? And why is our law enforcement not enforcing it? Those should be the individuals that are held accountable. This right here should hold a parent accountable, but again, they don't care. And there's a lot of them out there that are habitual with that, right? We see it on a daily basis. If you spent 30 years in the industry, you probably saw it on day one and probably as you were a law clerk. I want to appreciate y'all's time. Thank you. We're going to be here, I'm sure, late. How do you say your last name?
Lujan.
Lujan. I want to commend you. I drove 4.5 hours to be here today, and you're the only person who sat here and looked me in the eye the entire time I've been speaking. I appreciate that, and so does the public. Thank you.
Any questions with this witness, members? Chair hears none. Thank you for your testimony. Chair calls Steve Bresnen.
Mr. Chairman, my name's Steve Bresnen. I'm here very much in favor of this bill on behalf of the Texas Family Law Foundation. I really appreciate Representative Cook bringing the bill again. We supported this bill last session in 2017. We offered legislation to better enforce custody orders. We're down here a lot. We have different views from some of the people that have spoken tonight. People are complaining about having to pay child support when they don't get to see their kids. They're complaining about how much time they get in their orders. But what we've seen over and over and over again is many of the root causes of this problem are the lack of enforcement of custody orders. When you read 2503 that's cross-referenced in this bill, you'll see it's a pretty steep penalty. There's a state jail felony at the bottom of the list of defenses and affirmative defenses. It's a pretty steep hill to climb. Frankly, I think law enforcement and prosecutors ought to do a better job on that because it's clear from the decade or more that we've been representing people down here that there's been this problem. One of your colleagues in a previous legislature filed a 50-50 bill. And once we got to the bottom of what his son's case was, it had to do with he had the time. It's just that he was being thwarted in his efforts to see his kid by his ex. So something needs to be done. I want to point out some of the benefits of this that may not be immediately apparent to the non-lawyers. This is a broad grant of authority to municipalities and counties to adopt ordinances and orders imposing the civil penalty. When the law grants an agency the power to do something in general terms, it carries with it the implied authority to write the procedures that would go with it. And so officers can be directed via that procedure on how to conduct themselves. There'll be due process built in. Very frequently what happens is on the Class C misdemeanors, fine only, people don't pay the fine. And when they don't, their warrant goes out for their arrest. They can be arrested, brought up to the magistrate, put in the jail. When that starts happening, people are going to start complying with these orders. The other great thing about this is it allows the municipalities and the counties to have a variety of different kinds of orders. So some things that might work in Dallas or be a good idea there might not be in Abilene or San Angelo. And so there can be some experimentation going, if you will, and this can be developed in a way that becomes more of a lower laser focused. And finally, I want to point out that in many of these cases involving family turmoil, the cops have been out there before. Addresses get known to police forces. And after a while, they begin to sort things out. And I think that this has the potential to do that. It's not a panacea, it's not the end all, but it's a step forward to enforce these orders. We're going to have our differences on policy, but we ought not to have our differences on whether when an order is issued by a court, it should be enforced. Yes. Period, end of story.
All right. Thank you.
I'll be happy to answer any questions.
Thank you, Steve. Any questions of Mr. Bresnen, members? Now, anyway, I guess I had one, Steve. I was
Yes,
trying to reconcile in my mind. And I guess you're right, the municipality or the local government's going to have to kind of decide how to put the teeth in this.
Yes, sir.
So that police officers who go on the scene of something like this knows how to conduct themselves in terms of what they're supposed to ask and what they're supposed to find. Where there's competing claims, which there's going to always be, the police can, I mean, in here, I guess they would end up writing a ticket to whoever they found on the scene at fault.
Yes, sir.
And that person who was given the ticket could always go challenge the ticket, I suppose.
Yes, sir.
And then what happens in a municipal court is the state or the municipality would have to prove that the person was guilty.
Yes, sir.
And I'm trying to convince myself how they're going to do that.
Well, it's going to
Because
be,
a court order, if the court order says one thing and the other party says, well, I didn't violate the court order, but what happened was this or something totally anathema to the court order. What, I mean, and I guess like most municipal cases, you could even have a jury.
correct.
And I'm trying to convince myself in my mind how you get to the end. Because if the court fined the person and the person didn't pay the fine, you're right, they would issue a capers for you and you have to go to jail. And I'm not sure just how that all works.
I don't think it would necessarily have to, I think this is in addition to what I said earlier. I don't think you'd necessarily have, based on this language, there has to be a citation issued. I think, I'm just going to stereotype here for a minute. If the man is being denied the benefits of the order, they could file a complaint and go down, and the other party may have to come to court. JPs and municipal courts sort out these kinds of things all the time. It could be on the basis, take your don't have insurance for your car
Right.
when the officer pulls you over for
Right.
some traffic deal. You show up with your insurance card, and you show, we don't have this so much anymore. Some of these people are too young to remember when you had to do that, but,
Yeah.
all that's online now for
the
the
phone,
officer
yeah,
on the street, but, or you could have it on your phone.
Right.
It used to be you'd show up with your proof of insurance, but you had to show up. And if you didn't show up, in this case, if there's an officer on the scene, the child's not with one of the parents who's claiming that right, you may have to go down. They may not have the order with them. And officer, there's problems even with presenting an officer with evidence out there.
Right.
But officers sort these things out all the time on the street, and somebody ends up having to go down and show that, no, they were in the right or they were in the wrong. And the broad nature of this language, I think, allows for municipalities and counties to customize
Okay.
and work some of these things out.
Yeah. Okay. I hear you, and I think I understand it a lot better. And I think the devil would be in the details of how the local governments respond to this.
Yes, sir.
Yeah. So.
Well, somebody, I think it's far better than this legislature doing nothing. These orders have to be
Yeah.
enforced. A good amount of the conflict that shows up in your committee
Right.
could be resolved, I believe, if these orders were being enforced. And it's, lawyers are expensive. So to go back to court and seek a contempt order and to do it pro se is difficult, and to have lawyers is difficult. This is a non-lawyer way to go about it.
And judges sometimes don't want to find the custodial parent in contempt.
Sure.
Yeah. Okay. Any further questions, member? Mr. Bresnen?
Thank you all for your
Have your
service.
seat. Chair calls Jeffrey Morgan.
My name is Jeffrey Morgan. I am testifying on behalf of myself. I am testifying in support of this bill as well. A municipality may adopt an ordinance in order that imposes a civil penalty of not more than $500 for describing conduct, for the conduct described in Section 2503 Texas Penal Code. Section 25 of the Texas Penal Code is crimes against the family. This is a criminal action. And as others have said, nobody necessarily wants to see the other spouse have a criminal action against them. It's traumatizing to the children. This is something that, but it is law right now, it's just being ignored. When police officers get called, they say it's a civil matter. Well, make it a civil matter then, fine them. And I would say that perhaps instead of saying may, it should say shall, but that's something that the committee and others would have to decide. The devil is in the details, somebody said. I think it was Chair Dutton, you said that actually. The devil is in the lack of education of our police force. They always say that it's civil, generally speaking. Okay, so I've been in a number of these cases where I've watched them. Mr. Champagne, I've been able to watch his Olga Ventura. She's a disabled veteran and practicing nurse, pediatric nurse up in Rockwall, Texas. I've been to court with her about 4 times just to watch and observe what takes place. Police want to testify on her behalf. The judge would not let the police testify. She has not seen her kids frequently for years. So it happens not just to men, but to women. Like I've said, we've advocated for both men and women. Brandon will not talk about his story in the detail that I might. But he has an ex-wife that left him and went for another woman and everything else. I tried to go out there to just be a reasonable person, to say, let him see his kid. I went into the restaurant and just said, can I talk with the manager? She kicked me out, and she said, the kids don't want to see you. And so I called the police officer. I showed them the Texas Penal Code, and they would not enforce it whatsoever. I actually have video footage of that. Then we saw the video footage later on of the police officer, and he's joking about it, like, oh, I've seen this happen and everything else. That was dereliction of duty on his part. Went to the judge, the attorneys, everything else. It's been very bad what took place in that situation. Brandon's mother died several months ago. Had not seen the grandchildren for several years, was being brainwashed by the ex-wife. My stepfather is in a situation, again, he was kicked out of his home by his wife at the time. Police came to protect me. One day I was in the yard, and the police came to protect me. What's going on here? His ex-wife, or his wife at the time, was making threats to kill me, so the police came to protect me. What did I have to do with any of this stuff? Never miss a child support payment. Everybody's concerned about child support. Never miss a child support payment, everything else. He hasn't seen one son for over 40 years, and that's a shame because of the brainwashing that has taken place. Still trying to see him right now, but that's the result of not enforcing this. The only recommendation I might make is that perhaps, Representative Cook, you might consider a sliding scale, 500, 1,000, 2,500, or maybe at the fourth offense, flip custody, and also the child support obligation. That would have a very strong effect. Anyway, that's it. I appreciate it.
All right, thank you, Mr. Morgan.
Thank
Any
you.
questions, members? Not hearing any, thank you. Chair calls Delilah Crosby.
My name is Delilah Crosby. I'm representing myself as an advocate for Team Texas Penal Code 25.03, and I am in favor of this bill. First, I'd like to say thank you, Representative Cook. You are my representative, and Mansfield PD has tried to enforce this, the current interference with child custody. Not only has Mansfield PD, I have been successful with Waxahachie PD, I have been successful with constables in Dallas, and I have been successful with Mesquite PD. This is because I'm a woman. None of these fathers have been able to advocate for themselves, but I have been able to successfully advocate on their behalf to get these orders written up, these charges written up, I apologize. But the DAs is where we cut off. So if we're gonna have the DA saying, we can't charge this, we can't move forward with this, then we must move towards another solution, which is a civil penalty at this point. Our group, Team Texas Penal Code 25.03, originally had 13,000 members and growing. That group ended up hacked. We have since been growing in massive numbers still, even with our hack. And that right there shows that this is a continuing issue. Another issue about this is that if a father were to deal with interference and we are turned away, we are told we have to pay about $7,500 and up just to get back into the courtroom to get new orders, new temporary orders. And those attorney fees are never awarded to these fathers who had no choice but to go back to court. They already have orders that are not being enforced. Also, if we start writing up this as a civil penalty, that would become evidence for family court issues. That would be evidence to show the mental health effects on these children. My nephew has not seen our family for over 5 months now. Mother is in contempt of court orders, but father cannot afford an attorney right now. So we won't be able to see him until father can afford an attorney. If we put this through where the municipalities will be able to handle it, we'll move quicker with these issues instead of burdening the family court with more trials and cases. Also, I wanted to address your concerns about how the police will confirm that this is true. I kind of look at it as like child support. If fathers will say, I paid cash though, but I did provide diapers, but I did do that. And the courts will say, well, we didn't see it, so now you're gonna go to jail. This is kind of the same thing. Like, this is the orders, you could say that, but these are the orders, so we're gonna go by this, and police are not the law. So they just need to write up the charges and let the courts decide that. And then from the civil court, that father can now take it to the family court to truly address the custody battles and the issues that are going on with the high conflict parent. And as we stated, police officers do know the same address. As I've stated, I've had to do this numerous times with my own family, unfortunately. And Waxahachie PD eventually was able to get mother to start giving us the child. But that doesn't always happen, especially not for the fathers. So I do recommend that, yes, the language maybe needs to be clearer on how the police are going to. I already tell these fathers that court order you have, make sure you have a certified copy in your car at all times. It's more important than your birth certificate at this point. Just 2 weeks ago, I had a father go down to Mesquite PD and provide it in advance because we knew that mother was going to be violating the court order. And since then, the constables have assisted him. They have reached out to mother, and they have been able to resolve the situation. But it stops right there. It depends on who wants to help us. So this would bring a lot of resolve to this issue.
All right, thank you, Ms. Crosby. Any questions for Ms. Crosby? Thank you.
Thank you.
Thank you for your patience, too. Chair calls David Green.
Chairman and members of the committee, my name is David Green. I am testifying on behalf of myself, and I am for this bill. In the family court system, there needs to be more penalties put into place when one parent withholds a child from the other parent. This bill will encourage parents to encourage their children to have a relationship with the other parent. I understand sometimes children may be hesitant to go with the other parent as they may be hearing negative comments about the other parent, but having a monetary penalty will help discourage that kind of behavior, as the penalties for not transferring children over to the other parent is going to increase with the civil penalty. This bill will also reduce attorney fees, as there will be less cases of enforcement in family courts for denial of possession. Additionally, the parent who is being denied possession may have also had plans with their children, vacations planned, or expenses that have already paid for that they're not able to get refunded or reimbursed after they've been denied access to their children and they have to cancel everything they were planning to do. So this bill will prevent that from happening. So I encourage the passage of this bill. Thank you for your time.
All right. Thank you, Mr. Green. Thank you for your testimony. Any questions of this witness, members? Not hearing any. Thank you. The chair calls George Saldana.
Hello, my name is George Saldana. I'm for this bill. Thank you, Representative Cook, for bringing up this bill again. What was the third question? I always forget that one. Who do I represent? Yes. I represent myself, my children, and Texas Team 2503. I am the founder of this movement. September 1 of 2017, I started this. I started this because...
Wait just a minute now. Your registration says you're only representing yourself.
Oh, okay. Well, we can represent myself as well.
Okay. Well,
I mean, if you want to change it, you can. If not,
what do you want us to change it to?
And represent all the parents of Texas Team 2503.
Texas Team 2503.
Can I get my time back just a little
Yeah,
bit?
sure.
Okay, thank you.
What is it?
Oh,
Texas Team 2503.
correct. The parents, yes.
T-A-N?
Texas Team TEEN 2503. Okay. Is that what?
I don't know. Is it Texas Team? Just Texas Team 2503?
Yeah, that's what he said. Texas Team 2503, right?
Yes, sir. I'm the founder.
Okay, all
It's a
right.
grassroots organization.
Okay, so we'll show you as representing yourself and Texas Team 2503.
Yes, sir.
All right,
Okay.
you may proceed.
And I can get my time back, sir?
Sure.
Yes, sir. Okay. You want to restart it or no?
Go right ahead.
So I'm the founder of Texas Team 2503. There are systematic failures in place, and I'm going to go over some of them. I consider myself almost an expert in this field because since September 1, 2017, that's all I've been doing. Before that, I didn't know where my son was for 22 months. I called law enforcement. Law enforcement told me, if you want to find your son, go hire an attorney. Even though interference with child custody is included in the Code of Criminal Procedure 63.001 that states the retention in violation of a court order or judgment. 63.001 of the Code of Criminal Procedure refers to what a missing child is. So when I am awarded custody and I show up to the location, I call law enforcement, I want to know why my child isn't there, because at that time, child custody determination set by the Texas Family Code goes over possession and access as visitation and me having legal custody by the authority of the judge that gave me my court order. When I call law enforcement, I have a problem. For them to refer me and tell me it's a civil matter, this is a big issue. This issue is for me and for Team 2503, but it really goes out to Mr. Chad Reed. Chad Reed was shot in the chest while trying to locate his child. He has made the ultimate sacrifice for his child. Now, with these systematic failures, the Code of Criminal Procedure 2.05 says that a district attorney, if it be a felony, shall forthwith the felony before a magistrate of the county. Every policy and procedure that we have obtained through public information requests on these law enforcement agencies say they have to report this felony. We have to now go through internal affairs. Internal affairs has to do their investigation just to give us an offense report for interference with child custody. All this just to see my child. I haven't seen my child now. I saw him. I didn't know where he was for 22 months. I saw him for a little bit, got back into heavy litigation, and now I haven't seen him for 18 months. Kim Ogg, the Harris County DA, has an unwritten policy is to send them back. We obtained it through public information. That is an elected official oppressing me, my right to know where my fundamental right to my child, and going against the court order by not allowing me to bring that felony complaint before her office. I didn't legislate that. In fact, if this passes, September of 1973 was the first passage of this bill. It's going to be 50 years that people have been telling all these parents wanting to see their children, it's a civil matter. The Texas Attorney General sets up possession and access if they have Title 4D orders. But guess what? We don't help with that. But they'll get possession and access grant money from the federal government, and they'll give it to agencies to do research, just like all the statistics that everybody has been spewing out today. About 80% of the children that don't have fathers involved end up going to jail. So the passage of this would be great. Thank you, Representative Cook. Some of y'all might think of me as a bad man, but I come here to do business. I'm not here to fluff any feathers. Thank you.
Thank you, Mrs. Saldana. Any questions, members? Not hearing any. Thank you. Chair calls Kimi Lynn Reed.
My name is Kimi Lynn Reed. I am testifying for this bill. I'm representing myself, my son, Johnny Mason Murray, and Lone Star Family Advocacy. So, as previously mentioned, I have been advocating for approximately 3.5 years. The primary thing that we advocate for that started me in advocating is the enforcement of Penal Code 2503. Penal Code 2503, just to walk you through the procedure, Chairman Dutton, since you've heard so much testimony, I'd like to just walk you through that. So we will typically go to a police station on a Friday night or at around 6 o'clock and just wait around. You will, at 6 o'clock, you'll see the fathers, typically fathers, standing there waiting for an exchange to happen. They'll wait, 7 o'clock will roll around. We'll go up and say, hello, would you like some help with trying to garner access to your child? We'll walk them through the procedure. Do you have an original copy of your order? Okay, walk inside the police station. We walk inside the police station. May we get an officer? We wait for about an hour to get an officer to the co-ban. Once the officer shows up to the co-ban, we get the dismissiveness, just like you've heard others testify to. Civil matter, take it up with your wife, don't call us, basically. So then we've decided to escalate it. Well, give me your boss. So the boss comes out, and he is more often than not angered that we've bothered him. But then we amp it up by saying, listen, if you don't do your job and give this father a Penal Code 2503 felony offense for the parent who is withholding the child, we're going to do an internal affairs investigation for you come Monday morning. So begrudgingly so, we can twist the arm of a police officer and make them do their job. Now that we've made the police officer do their job, that father can do pretty much nothing with it. He'll go file it, and just as you've heard everybody testify to, district attorneys get to pick and choose the laws that they enforce, and 2503 is one of the laws they just choose not to enforce. They just choose not to. I have one father that I'm working with right now that we've actually been able to get 18 felony offense reports for, but the judge doesn't care. The judge sees 18 of those roll in, and this father still does not have access to his child. Adding a fine to this will significantly increase our ability to be able to leverage a parent to do the right thing. It's all we want is access. Thank you.
Okay. Thank you, Ms. Reed. Any questions, members? Not hearing any. Thank you for your testimony. Chair calls David Bellow.
David Bellow, testifying in favor of this bill, and I'm testifying for myself. Thank y'all for being here, listening to us testify in favor or against some of these bills. It is a tough job. Politics in general is tough. You got some people, one side hates you, some people on the other side love you, and then the next day they flip it and they'll love you on this bill and they hate you on that one. But at the end of the day, this is what's best for kids is what we should ultimately look at. And it's best for kids to have both parents involved in their lives. And it's a shame that in Texas, we have judges ruling on custody And then when one of the parents goes to get the child, the other parent just decides, oh, I'm not going to give you the kid in violation of a custody order. And, there's no remedy. It's against the law to do that. It's a state jail felony, and yet it's not enforced. Who knows? Maybe if the state passes a bill to require DAs to enforce the law, like it's going through the House right now, maybe you'll actually see a lot of people handing over their kids so they don't get hit with a felony. But a lot of DAs don't, I suppose, enforce this law because it is a drastic it's a felony. And so this bill, what it would do is it would give officers the option to issue a citation. Nobody wants to pay $500. That alone is going to make them know, let the parent who's doing the wrong thing know, this is a serious matter. And you're going to keep getting hit with $500 or worse if you don't follow the order and let the kid see the other parent. Because we've already gone over the detrimental effects of unequal parenting and fatherlessness. And this issue is not even about fathers. Equal parenting and 2503, interference with child custody, actually has to do a lot with women. We've heard of a lot of women who also are denied access to their children in violation of a court order. And so this is going to help women, men, and mostly it's going to help kids. And so I ask that y'all support this bill to help enforce penalties. And also I ask that you look into the root of this issue of why do parents not want to let their kid go see the other parent? And it's because when they first go to court, they're already starting off fighting because they're uneven and they're told they can fight for more time or keep the kid from the other parent. So if they go to court on equal footing as equal parents, then we wouldn't have a lot of these issues. But while we do have the issues, a fine for violation of interference with child custody would really help a lot of parents see their kids. And so thank you, Representative Cook, for filing this bill. And
Thank you, Representative.
Hope that y'all support
Thank
this.
you, Mr. Bellows.
Thank you very much.
Any questions, members? Not hearing any, thank you. And the chair calls Charles Suis.
My name is Charles Stephen Suis. I'm testifying for this bill, and I represent myself and my family. This is a good start. It's not perfect. It's not great. Could go further. We could say shall instead of may. It relies on the municipality to go ahead and adopt an ordinance. I have been advised to always carry a certified copy of my orders with me. I have them in each of my vehicles, and I have one by the front door, and I have an electronic version in my phone all the time. So the way I see this playing out is, you'll have the complaint, officer will come out, look over the orders. The municipality will already have trained him up, and he writes a citation right there and hands it over. I don't know if they use carbon copies anymore. In my day, last time I got a warning, it was there was a carbon, and I think I got the carbon, and he kept the original, and it went to the JP. That I think that's the way. And nowadays it may be electronic. This will probably work the same way, and then I might, if I'm making the complaint, I might have to show up and bring my orders with me. That might be part of the requirement. I don't know yet. This is a step in the right direction. It's not perfect. It'd be better. I'll take questions.
Okay, any questions of this witness, members? Not hearing any, thank you.
Thank you.
I believe that's all of the witness affirmations we have. Is there anyone else here who would like to testify for, on, or against House Bill 969? Chair hears none. The chair recognizes Representative Cook to close.
All right, thank you. I'm going to try to address just a few of the comments very quickly. I know we're short on time this evening, but this is local control. This does, as the last witness testified to, the may or shall relates to whether or not they adopt. It's not part of the elements of the offense. And so it is whether or not a city or a county decides to do that. Another issue was whether or not the fine of $500 was too much. This legislation gives the city and counties an opportunity to assess a fine or actually create an offense of anywhere between $0 and $500. It's not automatically $500. It's up to $500, no more than $500. And Chairman, I think to your question, I think what I would say is, we always hear like, the possession is 9/10 of the law, and in this case, that's what we're talking about is possession. And so I think the best thing that this bill will accomplish is compliance, and that's really what we want. That's what, as lawyers, as parents, as human beings, as people just trying to get things done in life, really what we want is compliance. And so when people go to court and they get a court order, they expect it to be followed. The judges expect it to be followed. And so whether this is a situation where a citation is being issued on the scene, like this bill provides, or someone in the alternative has to spend money and take it to court and seek an enforcement, I believe this is a much quicker and much more inexpensive option to enforce court orders. And whether or not there's jail time involved, I think a couple of witnesses talked about that as well. If you receive a civil offense and you don't show up, a judge can issue a second charge, which is a failure to appear, also can issue a summons or a warrant to have you arrested. Also, if you violate a court order in family court or in your divorce court, then you also can be thrown in jail for violating that court order as well. So lots of different options here. I just think this is a quick and easy opportunity to establish compliance, and I would ask your favorable consideration. I appreciate the opportunity to lay out House Bill 969, and be glad to answer any further questions.
Well, I was just looking at Penal Code 2503.
Yes, sir.
And it says a non-custodial parent commits interference with child custody if, with the intent to interfere with the lawful custody of a child younger than 18 years, he or she knowingly entices or persuades the child to leave the custody of the custodial parent, guardian, or person standing.
I believe that's Section B. If you look at Section A, it's where it talks about a custodial parent.
Well, that's what I was going to ask.
Yes, sir.
So
Yeah, I think
Section A is what this bill references. Is that right?
Google is, if you did Google, I think Google is misdirecting you. Because for some reason, 2503B pops up first, but 2503A would be the most likely scenario.
Okay, so 2503, well, since it's written that way, it would include both A and B, wouldn't it?
Yes, sir. That is absolutely correct.
Okay, and A.
So if your question is, this could also happen, if the non-custodial parent refused to return the child, then this could also be a situation where the officer is issuing a citation to the non-custodial parent who's overextending his or her welcome of the possession of the child.
Right, that's what I was getting.
Yes, sir, that is correct.
Yeah,
That is the intent, and I believe that that's how it would be enforced.
All right, okay, I got it. Any further questions, members? The chair will leave. House Bill 969 pending. 969.